Today's headline: September 21st marks the 53rd anniversary of the declaration of martial law in the Philippines. Every year, this date sparks debates. Some see it as necessary for order, others as a dark chapter of authoritarian rule. But what does the law say now, under our 1987 Constitution? And how different are things today compared to 1972? Let's take a step back. Under the 1935 and 1973 constitutions, the president was empowered to declare martial law or suspend the privilege of the writ of habeas corpus. These provisions were broad, and while they recognized national emergencies, they gave the president wide discretion. When martial law was declared in 1972, it lasted for more than a decade. Congress was padlocked, courts were undermined, and civil liberties were severely restricted. Simply put, the Constitution at that time lacked the necessary safeguards to stop abuse. Fast forward to 1987. Having just emerged from authoritarian rule, the framers of our present Constitution inserted safeguards in Article 7, Section 18, to make sure martial law could never again become a tool for dictatorship. Let's break these safeguards down. Under our present Constitution, the proclamation of martial law is time-bound. It should not exceed 60 days unless extended by Congress. Second, the 1987 Constitution provided for a system of checks and balances, first of which is the provision on congressional oversight. Within 48 hours from the proclamation of martial law, the president must report to Congress. The Congress, voting jointly, may revoke or extend the proclamation. Another check on the president's power to declare martial law is judicial review. The present Constitution expressly provides that the Supreme Court can review the sufficiency of the factual basis of the martial law proclamation within 30 days of filing a proper petition. This petition can be filed by any citizen. In addition to these, the Constitution also limits the effects of the proclamation of martial law. It expressly states that martial law does not suspend the Constitution itself, does not replace civil courts, and does not automatically suspend the privilege of the writ of habeas corpus. These constitutional checks have already been tested in recent years. In Fortun versus Arroyo, decided in 2012, the court made clear that the president's proclamation of martial law is not beyond judicial scrutiny. In Lagman versus Medialdea, decided in 2017, the Supreme Court upheld the martial law in Mindanao, but emphasized its power to examine the factual basis of the proclamation. Even though the court deferred to the president's appreciation of facts, the decision reaffirmed that martial law is not purely a political question. In short, unlike before, martial law today is subject to both political and judicial checks. Compare that to 1972. There was no time limit, no mandatory report to Congress, and no recognized judicial review. This lack of safeguards meant martial law could stretch indefinitely, which is exactly what happened. The framers of the 1987 Constitution deliberately closed these loopholes. They turned martial law from a nearly absolute presidential prerogative into an extraordinary power tightly controlled by law. So, what does this mean for us in 2025? It means that while martial law remains a constitutional tool to address rebellion or invasion, it is not a blank check. It is hedged by law, checked by Congress, and reviewable by the Supreme Court. For law students and bar takers, this is not just history. It's a live doctrine, a reminder of how constitutional law is shaped by experience, and how jurisprudence keeps the balance between security and liberty. 53 years since martial law, we look back to understand why our present Constitution was written the way it is. And every September 21st, the headline is not just about the past. It's about making sure the law continues to protect our freedoms today. This is Legal Lens. Law in today's headlines.